Sorry, I just started our recording. Your introduction got missed in the recording, but not the end of the world.
That's okay.
We did have a request to have this recorded so we could share it. So I am going to record this evening. I'm Michael Lapointe. I think I know pretty much everybody on here, but quick summary: I've been in the management world for over 20 years, and obviously I'm one of the owners of Desert Vista, and we are happy to have so many of our partner board members on with us this evening. Thank you all for joining. All right. We are going to start, as I said, with legislative updates and historical trends. And Charles and I are going to be sort of tag teaming this. And so we'll flip back and forth on slides, but starting off with you.
Awesome.
Sure.
Thanks so much, Michael. So as many of you may know, our Arizona legislature is very active. They are regularly looking at different things that are taking place within our state, trends that are changing, trying to be up to date with many different things. With that, oftentimes there is kind of some tension. Those that are in favor of community associations and seeking to protect the rights and privileges that come with community associations. And there's also sometimes groups that are against community associations or HOAs. As a result of that tension or those different groups, there are often many dozens of different bills that are proposed every legislative year that have some varying impact on community associations. 2025 was no different. In fact, there were dozens of different bills that were originally proposed, and many of those bills sought to change or modify, or in some ways, the bills were to reduce or minimize the effectiveness of associations or take some of those rights, peel those back a little bit. Thankfully, through the efforts of many, maybe even some of those on this call tonight, through community members, board members, management companies, attorneys, many that are involved in the HOA world, there were great efforts made to contact our elected officials and let them know things that we thought were good about the proposed bills and things that we thought were not so good. And many of those bills that were originally proposed did not advance to the point where they were presented to the governor for signature. But we are going to talk about a handful that did proceed, were signed into law, and as a result, will impact all of us in our communities. For 2025, the legislative session started at the beginning of January and recently adjourned. The session just ended in the afternoon on June 27th of 2025. In the state of Arizona, unless a bill specifically gives some other effective date, then the general rule is that a bill that is signed and goes into law will become effective 90 days after the date that the legislature adjourns. They call that sine die. And in this case, because of the adjournment on June 27th, that means that unless there's a specified date on the bill, which all the ones we're going to talk about today do not have a specified date, then the effective date for the bills we're going to talk about tonight go into effect starting September 26th, 2025. Sometimes I have people say, okay, so does that mean if I don't do one of the things that are listed in the presentation tonight that I'm now violating the Arizona law? The answer is no, because those have not gone into effect yet. Now, it is wise for boards and associations to prepare for those changes, and sometimes it does make sense to kind of change practices or behaviors so that you're in compliance in advance of those laws taking place or taking effect. But if someone came to me today and said, hey, one of these 4 bills that we're going to talk about, my association is not currently doing it today, my answer would be, that's okay, they're not required to. They aren't required to follow these new changes in the law until the effective date. And in this case, we're looking at September 26th. Next slide. Oh, perfect. So the first one I want to talk about is the tried and true area of the law that is constantly looked at by the legislature, and that is open meetings. There is a very strong prevailing principle within the Arizona legislature that they are routinely receiving complaints by individuals that say that boards are not doing things out in the open. And so it is not uncommon that each legislative year the open meeting laws, which under the Planned Community Act is 33-1804, and under the Condominium Act 33-1248, are routinely looked at for modification to make sure that the boards are doing the business that they are supposed to in the open. And so in this case, what happened is they were tinkering with and made some modifications to the provision that deal with recording. Some of you may have served on your board for quite some time and know that a handful of years ago, the law was changed that said, if you are going to prohibit or stop someone in your open meeting from recording, whether audio or visual, then the statute was changed to require that the board then must make a recording, and they have to make it unedited and keep it. Apparently, there's been some question about how long the association had to keep that recording, because it now is a business record of the association. And this revision that was now presented in the 2025 session and is going to become law September 26th for its effective date is that you must keep that unedited recording for at least 6 months. So a best practice pointer from my point of view is, if you are going to record, whether that be the manager, whether that be a board member, or if a member walks into an open meeting and says, I'd like to video this, and you say, no, we prefer you not to, then you would be making a recording, and you need to ensure that that recording is kept in an unedited format for at least 6 months. You may want to create, if you don't already, have some type of a video recording retention policy to make sure that you are following that guidelines and this statutory requirement. If you fail to do that, if you fail to keep that unedited record for at least 6 months, then you could be in violation of this new law that will be taking effect here in a couple of months. And we certainly don't want that for any of our board members or for our communities. And then, as listed at the very end there, because it is a business record, if you do receive that request, please remember that you need to make that unedited recording available for inspection within 10 business days. So you want to be able to coordinate very quickly with your managing agent to make sure that that is complied with as well. All right.
Okay.
We'll go to the next slide. Yeah, go for it, Michael.
On the implementation here, all of you guys have a meeting recording policy. For any new board members who may not have gone through all the policies, it is one of the best practice policies we present to all of our partner communities. So you all have a meeting recording policy. Up until now, the meeting recording policy has said if the board chooses to record a meeting, they will maintain that recording for 14 days. Well, now that requirement's 6 months. So we will be presenting all of our clients with a revised meeting recording policy in the next, in their August or September meetings. So if you haven't seen it yet, don't worry. Some of them might be in time for the July meetings, but everybody will get a new meeting recording policy that will detail the change. The only change will be that you have to keep it for at least 6 months. So we are revising those, and we'll be putting those in board packets here in the next 2 months. Historical trends on this, as Charles said, the legislation has, over the last several years, presented more and more changes to open meetings. Last year, they implemented a requirement that meeting agendas have to be provided at least 48 hours in advance. Prior to that, you just had to give notice of the meeting at least 48 hours in advance. As of last year, you also have to provide the agenda. That's never been a problem for us. We always provide the agenda, but that's now a legal requirement. So we put this in here just to sort of remind everybody and show everybody that the legislation is probably going to keep tinkering with open meetings, and based on the complaints they receive from a small handful of people, to try to make sure HOA boards are being as open and transparent as possible in meetings. And a little bit later in the presentation, we'll talk more in depth about open meetings and the exceptions to the open meeting law.
Awesome. Yeah, and I would just add that you're actually extremely fortunate to have a forward-thinking and progressive partner to help manage your community like Desert Vista, because this change in the law that is forthcoming with regard to the record retention policy, the fact that they're already planning and preparing to roll that out for you, that is not, I would say, a common occurrence. There are a lot of communities out there that are being given notice and made aware of these changes, but unless they take affirmative actions to request or to seek it out, some managing agents simply are, allowing that to be on the back burner. So I would commend Desert Vista for being ahead of the game in that regard. So great job, Michael, and your team.
Thank you, sir. Also, I had a question come in privately, but question was, if a homeowner starts recording because we're virtual, how would we even know? So good question. There is plenty of software out there where somebody can record their screen, including audio, that would not alert us, right? We've had people ask if they could record through our software, which is not a function we have enabled for other people besides us to start recordings in our software. But there is software out there people can use to just record whatever's going on the screen. Per the meeting recording policy that you all have, which basically does as much as you can under the law, people are supposed to let us know they start recording. They don't have to give advance notice. They don't have to tell us a day before, 2 days before that they're going to record a meeting, but they are supposed to let the chair of the meeting know that they're starting a recording, which does give you the opportunity to say, no, we'd rather record it on our side. However, if somebody does record it, the meeting recording policy that each of you have for your associations does detail what they can and cannot use that recording for. And basically, unless you guys choose otherwise, your policies all say that they cannot use it and disseminate it on social media to the media. They can't transcribe it. Basically, all the things the law says you're allowed to put in place. They can use it for dispute resolution. You have to allow them to use it for dispute resolution. That's the purpose of somebody potentially recording it. But if they record, not the end of the world, no big deal. They're allowed to do that. It would be appropriate for them to let us know up front, but shouldn't be any problem there.
Michael, another question came in, which is, if they don't tell you, can they use it in court? The answer is yes. With our day and age of technology and the multitude of devices, whether you've got the Ray-Ban sunglasses that record out of its lenses, or not the lenses, I'm sorry, the frames, or, if someone just has their phone upside down and has pressed record, the reality is that there's a multitude of ways that people can record, and some we may not even be aware of. My best practice recommendation is we always just want to behave and comport ourselves in a way that if what is taking place and the things that we say and the things that we do were to be presented before a judge or put on the 6 o'clock news, would you be comfortable with your actions and behavior and statements? And if the answer is yes, then you should be perfectly fine.
Now, to add to that, that's also why all of our communities have a best practice policy, conduct of meetings policy that kind of references the fact that we're going to behave professionally and treat everybody with respect. And we can't control how they act, but just assume you're being recorded at all times, whether you are or not. I have a community where a homeowner shows up to most meetings, and at this point we know, but he wears a body cam. It's like a little pen in his pocket that records. And so we know every time he shows up, he doesn't say anything, but we know the meeting's being recorded. We know if we run into him in the community. So, bottom line is, I assume that when I'm on the phone with a homeowner, when I'm in a person with them, or when I'm in a meeting, that I'm being recorded and to behave accordingly.
Yeah. In the original recording statute portion of the open meeting law was designed, going back to your question of can it be used in court, was designed so that there is some record that if you prohibit a homeowner from being able to record, that there is some record of what took place so that they can do a records request and utilize that information in an unedited format for potential court action or litigation if it needs to be. So the general answer is yes. The general answer is when either the association itself or some member who's in attendance records a meeting, it is very possible that that could be utilized in a court proceeding, unless there's some other reason why it should not be. For example, you know, if they snuck it into a closed executive session, for example, and tried to record a closed executive session, well, even though they have the recording, that might be something that a judge would agree should not be appropriate for use as evidence or being submitted in the court record, because it does violate one of the statutory protected spaces for that discussion and dialogue. But maybe we'll touch on that a little bit more as we talk about the reasons why you go to a closed executive session later in the presentation.
Charles, just to wrap this up on this section here, in terms of recordings and recording meetings, I think I actually lost my train of thought. You know what? I'll think of it later, but I had a great thing I wanted you. Oh, I was going to weigh in and say, listen, the general consensus from legal counsel in our space, in our industry, is that you not record your meetings. Charles can tell us if he feels differently. But at the end of the day, your meeting minutes are supposed to record all board actions and decisions, not discussions. The goal is really not to record discussions that may or may not always be accurate. Nobody sitting in a board meeting, including your manager, is an expert in every field, and sometimes things get said incorrectly, and having a recorded record of that can be problematic. There are, however, plenty of communities, often your larger ones, who record all of their meetings and post them to their websites and leave them up forever. So there's no right or wrong way, but I think the general consensus from Association Legal Counsel is not to record as a default method.
Right. My preference is not, unless you have a overarching prevailing purpose that needs to have the recording. I agree. Your minutes should be exactly that. They're minutes. They're not seconds, which is bare bone, nothing there, but it's not hours. It needs to be the actionable items. You have your agenda, you have the information as to whether or not the measure proceeds and passes, or it fails. And it should not be some verbose, long, drawn out thing. But no, I'm not a huge fan of, on a practical basis, to record every single meeting every single time, unless there's a good reason to do it. All right, that's going to turn our attention over to the lien. In the state of Arizona, many of you may know that there's two types of remedies that an association has. One is against the person. That's for a claim called a breach of contract. The other is a lien, and the lien is actually attached to the real property. In most cases, we're talking about the actual home that person owns within your community. In the state of Arizona, there is a lien foreclosure statute. And what's a little bit unique about this particular bill that was proposed is it sought to change the time and the dollar amount that are the triggering variables that allows an association to proceed with a lien foreclosure. For many, many years, the lien foreclosure statutes for planned communities and condominiums have mirrored one another, which is to say that they had the same requirements. The traditional last several years, the threshold has been either $1,200 in delinquent assessments or 12-month delinquency in assessments, whichever you meet first. So either of those two variables, as soon as one of them is met, then it is, in the legal parlance, we say it is ripe, or it's ready to then be filed for foreclosure. For purposes unbeknownst to me and many that I've talked to that are involved in the lobbying efforts and down at the legislature, this bill that was proposed in 2025 seeks to change only those variables as it pertains to the Planned Community Act, which is to say single-family homes, things like that. The Condo Act is not part of these changes. So if anyone on the call is in a condominium, you're welcome to plug your ears for a minute, because this will not apply to you unless they come back in 2026 and kind of square this up and make them similar in nature next year. But for right now, the Condo Act still says 12 months and $1,200 are the two variables. One of the two needs to be met. For those in planned communities, beginning in September, on the effective date, the $1,200 and 12 months will no longer apply. Instead, the time requirement will move to 18 months in delinquent assessments, and the dollar amount will change to $10,000. Well, I can tell you from my perspective that the vast majority of community associations throughout the state of Arizona in Planned Community Act that are subject to the Planned Community Act likely will not reach that $10,000 threshold in delinquent assessments. Instead, what this change has really done, its true either stated or unstated impact is, it's kind of taken the dollar amount off the table, and now it's going to be very much a evaluation of whether or not it reaches an 18-month delinquency. Another slight change is the language was modified to say that 18-month delinquency applies to any assessment or portion of the assessment, which I believe is actually good modification to the language, because there were times where individuals would, make a nominal payment. In essence, if it was strictly 18 months in 18 consecutive unpaid assessments, then a person could merely pay a $5 nominal de minimis payment to try to frustrate that full 18-month time period in a continuous delinquency. Now, unless they have satisfied the full amount that is required in that 18-month window, then it would be subject under the statute for a possible lien foreclosure lawsuit to be filed by the association. Do you have any comments on that one, Michael? You want to weigh in on the foreclosure lien?
No, not in terms of that, but I think you covered everything well there. I would say that, I don't think we as an industry, we as a company are concerned about the change from the standpoint that nobody's really ever going to reach the 10,000 threshold in a planned community. It would be rare. The time frame is going to be reached first, and so the time frame really has gone from 12 to 18 months for foreclosure. It's not that big of a change. It is going to, prolong and some of the delinquencies a little bit, but it's not that bad. But right. It speaks to, again, a trend going on in the legislation in terms of how we're handling things. And there's a couple things up here in 2024. They changed assessment collections last year. Late fees are only permitted if they're actually called for in the CC&Rs. We have several communities who still issue late fees, but they are not actually part of the lien anymore because they are not called for in the CC&Rs. So if you get to that point, your late fees may not be collectible. That same law last year said reasonable attorney fees and costs are no longer secured by the lien unless they are awarded by a court. So securing the judgment is, as more important than ever now. Most right. HOA documents state that reasonable attorney fees are included in the lien, but the legislature said no, unless they're awarded by a court. So just some things like that. Interest is no longer secured by the lien, and the board has to offer a reasonable payment plan, which all of you do just based on your assessment collection policies anyway. But that followed, the biggest one was 2022 when Proposition 209 was passed. It was billed as the Medical Debt Relief Act, but what it really did was made garnishment almost an impossibility for HOAs, because most people who are being garnished don't meet these requirements. Now, instead of only $300 being protected in somebody's bank account, the first $5,000 is. So they have to have more than $5,000 before their bank account can be garnished. They have to have annual wages to garnish their wages of more than $50,000. And the truth of the matter is, as individuals, a lot of people who are in a bad spot from a collection standpoint simply don't meet those requirements. So 2022 is when our only other real device, garnishment, sort of went away and left us mainly with foreclosures. And now legislature is trying to figure out how to make that process more difficult for HOA. So probably a trend we'll see continuing in the coming years.
Yeah, a couple things. I would just slightly, I think that Michael is spot on with the impact of Prop 209. I would say that there are circumstances where it still is a very viable circumstance. In fact, if you're talking about former owners, that's your only option. And so there might be appropriate times where it works, but is it a preferred method? Well, a lot of the efficacy or the value in it has been impacted by that Prop 209 for sure. And then we had a couple of questions. Joe from Silverhawk asks, what effect does this have upon the liens already in process under the current law? Joe, really good question. Normally, bills that are proposed that then become law are not retroactive. Unless the statute expressly says so, then you do not look backwards and apply it to things that already satisfied the requirements. So I'll give you two quick examples just to hit home the point. One, if you filed a foreclosure lawsuit today and you lived in a planned community, you would need to satisfy the 12 months or $1,200 requirement. If I did not file that foreclosure lawsuit until, let's say, October 1, which is after the effective date, then if that file only would meet the $1,200 or 12 months, then I could not file that lawsuit. So if when you say already in the process, that process needs to mean that it has filed a foreclosure lawsuit. That is the process. If what is intended by in the process is to say, well, we place that file with our attorney, therefore we get to keep the old $1,200 and 12 month, then unfortunately that would not apply. It would need to be a filing of a lien foreclosure action prior to the effective date in order to use the current standard, which is $1,200 and 12 months. After the effective date, any foreclosure must meet, for planned communities, must meet the new change, which would be 18 months or $10,000. And again, exactly as Mike hit the nail on the head, very rarely do I anticipate we'll hit the $10,000 threshold. Instead, we're more likely looking at an 18-month time period for the variable to be satisfied. And then Alex had a question, which is, does this include any situations where special assessments may be required in the excess of $10,000? If I understand the question correctly, is can the special assessment dollar amount be calculated within the $10,000 quantity? And in that case, I would want to look at your governing documents, specifically your CC&Rs, in the definition section for what is a part of an assessment and part of the assessment lien, because some CC&Rs will allow for the definition to include different types of assessments, and they are all foreclosable. Whereas other CC&Rs might say, yes, there's a utility assessment, there's an enforcement assessment, there's a special assessment, but the regular assessment is the only one that is foreclosable in the same manner as a mortgage. And so I raise that as a possibility that you would want to make sure, based on your specific governing documents, whether or not the dollar amounts you're looking at do apply towards the dollar amounts for an assessment that is foreclosable versus an assessment that is merely contractual, if that makes sense. All right. Moving right along, we get to Senate Bill 1378. This I don't think was a monumental change, but it certainly can and likely will have some impact. We are past our most recent political cycle, although I don't think we ever get out of our political news. It seems like everything is political nowadays. And with that, what we find is signs and flags become big issues. As many of you may know, under the Planned Community Act and the Condo Act, there are specific statutes in both of those statutory schemes that deal with what constitutes a flag and what constitutes a sign, and when they are protected by statute and when they can and must be allowed to be displayed on persons' property, on their lots. The big change here is that if you look historically, and let's just look at presidential campaigns that we've seen over the last couple of cycles, we saw a lot of signs, but we also saw a lot of flags. And there are some communities that have outright prohibition that say no flags at all. Well, for us, we know that even if you have an outright prohibition, there are statutorily protected flags that you must allow. And there's a laundry list of what the statute lists that provides that they can fly those flags, so long as it's no more than 2 of them at a time. And that can be everything from the United States flag to the Arizona flag, the Gadsden flag, first responders flag, the Betsy Ross flag is now protected. There are several flags that are protected and can be flown. Well, what about those that had the Trump flags or the Biden flags? Are those protected flags? And in the past, the answer was, if you had a community that had an outright prohibition on flags, the answer could be, no, those are not permitted. We're not choosing. We like that candidate so they can fly theirs, and we don't like that candidate so they can't fly theirs. No, you don't regulate the content. You regulate whether or not it's a permissible thing or not. And in the case of we'll just use the example of the Trump flag and the Biden flag. If those 2 flags are not permitted under your governing documents, then you had a basis to say, no, we're sorry, those are not permitted. You need to take them down. The same conclusion would not apply if they had a sign. If they had a political sign in their front yard and it met the statutory requirements for size and time period to be displayed, then if someone had a Trump sign versus a Biden sign, then in that case, you likely would not have the ability to say, hey, you have to remove both of those signs because they were protected under the sign provisions of the statute. Well, now the legislature has added the word flag, as is quoted here, so that certain political flags, so long as they comply with the remainder of the statute, meaning size and time period, can now be a protected political flag during that cycle. So the language itself says means a sign or flag that attempts to influence the outcome of an election, including supporting or opposing the circulation of a petition for a ballot measure, question or proposition, or the recall of a public officer.
This to me is a classic example of a law that happened, honestly, in my opinion, because of association overreach. I don't think we have a community on here, at least not while they were managed by us, that has ever tried to make somebody take a political flag down during appropriate political sign timeframes, because we've always said that's a battle you probably don't need to get into. But those battles have led to this law change, because there were HOAs who were like, no, we're gonna fight that fight. That's a battle we want. It's sort of like, pride flags. By and large, most communities say during the month of June, we're not really going to cite those. If a neighbor complains about one and we have to cite it, so be it. But we're not going to try to actively cite them during Pride Month, and so it's just, this is one of those same types of things of, you got to find a way to be reasonable with enforcement and pick your battles. And unfortunately, too many communities, I'm not going to name any that I know of, but I do know of a large one in the Santan Valley area that regularly went after this. I heard about them all the time going after this during political season. And it just doesn't make sense, because it's no different than a political sign realistically. And so now that's the law.
Yeah, and now it doesn't matter, because if there was a splitting of hairs in the past, this language takes away that discretion. And I love what you said, Michael. Really, we want boards and communities to be reasonable. It's the unreasonable circumstances that create sometimes outlandish and sometimes onerous laws. And so we encourage and support our boards to follow the law and to try to be as fair and reasonable as the law permits. And to go along with that, and there is the notation here, if you don't already, similar to the recording policy that's being updated, you may need to take a look, if you have existing flag and sign policies, to make sure that you're updating those policies as well to be in concert with this new change in the law that's going to be upcoming here in September.
Charles already touched on this, but part of that historical trend thing. It was just a couple of years ago when into the laundry list of flags, which we'll cover just momentarily again here in a second. Um, any historical version of the American flag, including the Betsy Ross flag, got added to the list of flags that have to be allowed. Not sure if you are all fully aware, but there are currently over 40 flags that an association cannot prohibit. You don't have to allow 40 flags to be up at the same time. You can limit them to 2 flags, but you have to allow any of these 40 flags, and that's the U.S. flag, the Arizona state flag, the Gadsden or Don't Tread on Me flag, any branch of the United States military service, including Space Force, the Palmia, the Blue Star, the Gold Star, any of the 22 Arizona Indian Nation flags, any of the historical versions of the U.S. flag, and then first responder flags, like your thin blue line and thin red line flags and things of that nature. So again, over 40 flags that you cannot prohibit, although you don't have to allow them all to be flown at the same time.
There was a comment of what about Cardinals or Suns, and I'd add Diamondbacks, and I am a native of Arizona, so I love those teams. But I also know that our fan base only allows the flags if they're winning. If they're losing, then I don't think that your neighbors will allow you to fly the flags. I think that might be the rule that they require. But jokingly,
Yeah. To answer
go
your
for it,
question, though,
Michael.
truthfully, Melissa, we actually have communities whose rules say, well, maybe it might not be completely cohesive with their CCNR, but their rules say sports flags are allowed during appropriate sports seasons. And seasonal and holiday flags are allowed during the appropriate seasons and holidays, all of that stuff. And so I think our recommendation on that is, again, be reasonable. Is that flag hurting anybody's property values? You're in a condo. Have they attached that to the exterior of the building that the HOA maintains? Because now I might have a problem with that. But do they have a removable bracket around their balcony railing and it's up there and it's not in bad shape? Is that a real issue? In my opinion, no, but the board can decide if that's an issue they want to tackle. But I think it's one of those reasonable things you have to consider. I jokingly say, as a Cowboys fan, every time I drive through a community and see a Philadelphia Eagles fan, that person's instantly in violation. I'm citing them for everything.
And I'm going to say that the Cowboys fan is in violation too. Heck no, we don't want those. They already take up all of our seats in the stadium. We don't need them flying their flags as well.
Joe, to answer your question, yeah, we don't have to amend the CCNRs, and that's easier said than done, obviously. You can often just create rules that say, hey, we know our CCNRs state this, but Arizona law says we can no longer prohibit this, and so this is what's allowed and how it's allowed. It's sort of like for meeting recordings, most HOA documents themselves are pretty silent about recording meetings. But Arizona law says you have the right to create rules or a policy regarding that based on the law. So you create that based on the law. So yeah, perfect way to handle that.
Yeah, and as just a side note, that's a really good point, because sometimes I'll be asked questions by boards that say, well, I understand that's the law, but my documents say this other thing to the contrary, so I have to follow my governing documents. And I'm glad that they are very concerned with following their documents. That is a good thing to be aware of. But remember that the law trumps and supersedes any of our governing documents if they are in conflict with one another. And so whether your documents say you must do X and the law says, no, you have to do Y, you cannot do X even if you wanted to. You have to do Y, because Y is what the law requires. So, all right. We're going to get to the last one. Yeah, go for it.
Doesn't actually apply to any of our communities. So can we just be a little brief on this one in the interest of time?
We're going to do this in 30 seconds or less. If you decide to move into a condo, the new status of the law is if there is a difference between commercial versus residential structures and use, then the common expenses will need to be tracked and essentially allocated accordingly. And if there's a dispute between the two parties, the commercial and the residential, as to who is responsible for what. It is the association, the condo, that bears by a clear and convincing standard to show that the commercial side is required to pay a certain amount. And as you can imagine, where this came from, commercial contractors and vendors were very much involved in getting this clarification and passed in the legislature.
What's interesting to me about this one is that it only applies to condominiums who have separate commercial structures. So if you think of a high rise or even some, standard, I would call them mixed use condo communities where you have condos up top and businesses down below. If they're not separate structures, this does not apply. It only applies if they're separate structures. I found that interesting. I also found it interesting that it only applies to condos because there are plenty of planned communities that have commercial portions. There's a shopping center and a Home Depot that are technically part of the HOA, and this was not addressed at all with regards to planned communities. So I find that interesting. Okay, we are going to discuss safe harbor business judgment rule briefly. It's just a good time to probably remind everybody that, your manager's not a legal expert. I'm not a legal expert. I think I'm pretty well versed on HOA law, but I can't give you legal guidance. And so there is an Arizona statute that gives you what we call safe harbor. It is known as the business judgment rule. And essentially what it says is if you rely on the advice of information provided by reports, etc., from certain classes of individuals, you are protected in your decision making. So in other words, if you get legal advice, if you rely on a report from a CPA for your end of year financials, if you have established a committee of people that you feel are competent in an issue and to research that issue and come to you with their findings, you can rely on those things and make a decision. And if that decision ends up being maybe not accurate, you are protected from personal liability because you are following the business judgment rule and you have safe harbor. Maybe
Michael, can I pose a question to you?
Sure.
So I'm really good at mowing my yard. If I come to your board and I present and say, hey, you know what, I've got all of these hours of experience at my home doing this landscape work, let me tell you how to do this complex, 200-acre irrigation system plan for X community association. Is that reasonable reliance? Should that board feel safe under safe harbor principles, do you think?
No, I think that if you're relying on an individual, that person has to be licensed in whatever it is you're getting the advice from them. If it's a committee who's doing research, their research needs to include talking to experts, so it does have to involve experts that you are relying on. And while I think I'm an expert in HOA management, my expertise does not translate to expertise you can rely on legally. So we still have to go to those experts from time to time, which is why we will recommend you get, legal opinion for something, because even if I can feel confident telling you definitively that your documents say this, I'm not a lawyer. I don't get to tell you with 100% surety that you can rely on.
I totally agree with that. And what I encourage people to do is, so the statute says you've got to act in good faith with the reasonable belief that what you're doing is in the best interest of the association, and act as a person in a similar circumstance would act. And so how do you satisfy those three requirements? Well, you should be dealing with people that are licensed, bonded, and insured for the type of activity that you need the service. So you give the example of legal advice. Well, there's tons of attorneys out that are licensed in the state of Arizona. But would I encourage you to go talk to a medical malpractice attorney about your in-depth HOA needs? Probably not.
Law.
What's that?
Top Dog Law.
There you go.
We all know those commercials.
Yeah. I mean, I actually, earlier in my career doing HOA work, I actually had a board specifically say, Charles, we want you to come up onto the top of the roof with us and tell us all of the flaws of this roof. And I told them, I said, you know what, I'm happy to go up there with you, which is not uncommon for an attorney to go up there. Usually it's because the contractor had their attorney up there. You want to make sure that, you know, you're on equal footing, no pun intended. But I'm not the person that is going to give the conclusions and findings as to what's wrong with that roof. That needs to be a roofing expert that can stand behind their inspections and conclusions. And the way that they stand behind it is not only through their licensing, but also their bond and their insurance. That way, if they're wrong, then you have some kind of fallback position for protection. And that's kind of the overarching principle of why it's so important to use experts in their given field, because you want to make sure that as much as possible, you are appropriately shifting the risk to those providers so that if they are wrong, you have some kind of a recourse or recovery. So, but no, I wholeheartedly agree with you, Michael. I think safe harbor is a critically important principle that board members should constantly be striving to be in.
I'm going to ask
Yeah.
you, we could spend an hour talking about Callaway versus Calabria Ranch. I'm going to ask you to give us 3 to 5 minute summation of this and everything boards need to be aware of.
Okay, I'm gonna boil it down to this. The Arizona Supreme Court, through this case, has, however you look at it, either reconfirmed or created new requirements, depending on your viewpoint of that holding, that in order for you to change your CC&Rs, if you are going to create a new restriction, that restriction has to be tethered to your existing and original CC&Rs at the time that that owner took title to the property, became a member in your community. If you can have some kind of a tether or connection, then you likely will be able to modify your CC&Rs under your normal CC&R amendment provision. If you are creating a brand new, untethered, unforeseeable restriction in your community through a revised CC&R amendment, then it is very likely that you cannot do that lawfully without obtaining 100% approval of the entire membership. And the skeptic in me tells me that that is very unlikely. It's very unlikely to get 100% approval by all of the people in your community.
Right. When this case came up and this ruling came out a few years back now, and there have been other cases to affirm this decision since then. But when this happened, you know, we had several communities at the time that were actually in the process of trying to do amendments. The biggest ones, and I think plenty of boards would still like to tackle them, but the biggest ones at that time were wanting to implement short-term rental restrictions and wanting to, for communities that don't already have something that says it has to be at least 30 days or at least 6 months, wanting to implement short-term rental restrictions, wanting to limit rentals, and wanting to, for communities that don't have any sort of resale fees, be it a working capital contribution or a reserve contribution or a transfer fee, wanting to implement something of that nature. And all of those basically came to a halt because you can't, if you don't have anything in your documents, you don't have anything to tether them to. You can't go as far as to stretch and go, well, we have a section that talks about rentals. Even though it says nothing about a time frame, we're now going to add in a time frame. That's not an amendment that was foreseeable. There's got to be that foreseeability stance there. So this is when any community brings up amendments, and we've done several of them for you guys, for several of you guys on the call, and successfully done amendments. But when anybody brings it up, these are the things that we think about that we then talk to you about. Is this one we should really consider moving forward with? If you do move forward with one that may not meet these requirements and you pass it under what your CC&R state, it only takes one person to challenge that. and likely win, and then none of it matters. You spent all that money and time for nothing. And quite frankly, the bad part about the Callaway case, which is talked about in Charles's slides here, is that it does lead way for somebody to go after prior amendments that have already been done in the past, too. Correct, Charles?
Potentially. I mean, the threat of the litigation is certainly there. Whether or not they'd be successful would completely depend on the facts and the circumstances of how it was undertaken. I will also add that when this originally came out, there were many different associations that said, they threw up their hands and said, well, I guess we can never do any amendment ever again. And the answer is that's not entirely true. You really need to take a look, and I would encourage with your legal counsel to do an in-depth review of whether or not you do have that tether. Do you have the foreseeability element satisfied? And if the answer is yes, then by all means, amendments are still on the board. But if it is 100% unanimous consent that you're going to have to obtain because it's a brand new, never contemplated thing, then that's going to be a very difficult hurdle for you to overcome. But I would say, at least from a due diligence standpoint, it is worth talking with your qualified managing agent and likely with your qualified legal counsel to do an evaluation of whether the thing that you're pursuing can be reasonably obtained, yes or no.
We're going to spend a few minutes now talking about open meetings and exceptions. We only have a little bit of time left. I'm probably going to ask you guys for 5 extra minutes, but we are going to spend some time talking about this. And by the way, we will send out a PDF of this presentation. Your managers will get those out in the next day or two to everybody. So you'll have this to refer to as well. But open meetings, as you all know, we usually have 2 types of meetings, our open meeting and our executive meeting. I don't need to get into the purpose of the meetings. They are for board business, as we talk about often. Owners do have the right to speak at certain times, and we will make sure they are afforded those times. But what's really important to note is skip through some of the noticing requirements because of the fact that we've already talked about those. I do like to point out that if you have committees that meet regularly scheduled committee meetings, must also be open to owners. If you have a committee that doesn't really meet but needs to meet this month, there's probably some gray area there on whether or not you have to notice that meeting, because it specifically says regularly scheduled committee meetings. But we really want to talk about are the reasons that we can go into executive, the exceptions for open meetings. And actually, I do want to step back here to, first and foremost, boards still have the ability to conduct business via unanimous written consent if necessary. For those of you that just don't have enough going on to meet monthly and you only meet every other month or quarterly, if something comes up in between those meetings that can't wait till the next meeting, unanimous consent is fine. But it is the intent of Arizona law that homeowners be privy to all discussion that go into decisions. So they really want most decisions being made in an open meeting where the discussion is happening and homeowners can hear the discussion. So we do want to limit as much as possible unanimous written consent, but it is still a legal option for you. You can also hold emergency board meetings if there's an absolute emergency. We had a community that on the 4th of July had backflow preventers stolen. They cut the cages open and cut 2 of the backflows off the morning of July 4th, right? So those needed to get replaced ASAP. We went ahead and told the board that the board was okay with it, that we were going to just get them replaced under the emergency provisions of our contract. But realistically, the board could have held a quick emergency meeting without noticing the community to vote on the proposal from the landscaper to replace those if they wanted to. So that is a possibility if it's an actual emergency. All right, here's the 5 things. The 5 reasons we can go into executive meetings, 5 things that can happen in executive. Legal advice from an attorney for the board or the association. If you have a legal opinion or the attorney's coming to discuss legal advice, all of that is perfectly fine and should take place under executive session. Pending or contemplated litigation. I am not suggesting this, but this is probably the one that boards take the most advantage of, because they could be pending litigation in this matter, but realistically, this is designed for things you're going to be filing suit on, or that you have a suit on, or you've been sued over, or whatever the case is. The next one here is the personal health or financial information about an individual member of the community. So maybe somebody's having a hard time making their payments and taking care of their home because of health issues, and you need to discuss that and how you can help them out. That's fine. The personal health or financial information about an individual employee of the association. I don't think we have very many communities that have actual employees, or an individual employee of a contractor for the association. So maybe you were wanting to discuss the personal health information about your manager or about your landscape account manager, and see what you can do because of the situation they're in to help them out. Send them do we want to do something nice for them, whatever. That's fine to discuss in executive session. Also, matters relating to the job performance or compensation of, and again, health records, which is kind of funny, but the same groups of people: an individual employee of the community or an individual employee of a contractor. Boards stretch this one all the time to interview management. You're not really allowed to, but it happens. We know, because we're interviewing and it's just the board. It's not really supposed to. It is interesting. A lot of other states actually have management contract as one of the things you can discuss in executive session. And it's also interesting that there's such a stigma around letting your current management company know that you're not happy and you're going out to bid, because I think you should always let all your vendors know you're going to go out to bid on landscape. Hey, landscaper, board's not happy. We're going out to bid. We're going to let you bid again, but you need to understand they're not happy. You got to pick it up. And then discussion of any member's appeal of any violation cited or penalty imposed. If somebody's appealing a fine or a violation or has requested a hearing, all of that is an executive session. It is important to note that that particular portion, though, is stated under the law as, unless that member requests to have that done in open session, if they want to have their hearing in open session, that is their choice. You have to then hold it in open session. I say all of this. We wanted to put this section in here and remind everybody of this, for the simple fact that, a lot of communication happens all the time between meetings. It's hard to stop. It's hard to, and we understand that. And we're not telling you shouldn't have any conversations with each other at all between meetings or anything of that nature. But we do want you to understand that the intent of the law is that when we make decisions, homeowners get to be privy to those discussions. So when we show up to an open meeting, we have to have some discussion around decisions. It can't be, we're voting to approve $40,000 and there's no discussion that anybody's heard because you've had it all on the side. There has to be discussion. People need to hear the reasoning. You can be prepared to make a decision, but you gotta have some discussion around it at the meeting so people can hear that, and be understanding of what decisions you're making. We had a question in here about how does this affect emails among board members? Well, anytime a board gets together, a quorum of the board gets together to discuss association business, that is technically a meeting under Arizona law. They specifically say that. That would include email. It would include phone calls. It would include, quite frankly, discussions on social media. If you're on your nextdoor.com page or your neighborhood Facebook group, and a quorum of the board is engaging together in there, you're now in an open meeting. So you do have to be cognizant of that. There's workarounds. If there's something you have to discuss in advance of the meeting, we often see the board president call each individual board member and say, hey, I need to discuss this with you, make sure we're all on the same page before we get in there, but not all together, because then you have a quorum of the board. So there are workarounds. We send out emails, that our management reports, or hey, an FYI. Sometimes they lead to a little bit of discussion, never a vote unless we're specifically asking for a vote, in which case we don't want discussion, we just want your vote. But yes, it is almost impossible to stop all discussion between meetings. The goal, though, is to make sure that by and large, we're making most of our decisions in meetings. We're minimizing unanimous written consent, and we are making sure homeowners are privy to the discussion and the reasoning behind the decisions being made. And of course, part of that is making sure homeowners have the right to chime in on anything the board votes on after a motion's been made and seconded and before the vote has actually been cast.
Michael is a practice pointer that I have seen that to be helpful, because I would agree. You do not want to engage if you meet the two requirements of having a quorum, a majority of your board, and discussing association business. Again, discussion. It doesn't say anything about requiring a vote, none of that. But if you're talking in the context of email, something that could be helpful is that use your community manager as a fantastic conduit for those communications. If you have something that you'd like to be disseminated to the rest of the group, send it to the manager, have it, go through that channel, and then the manager can actually send it out to the entire board via a blind copy email, which is to say that the manager can send it to the entire board with each recipient being blind copied, which means that you cannot have this continuous thread of dialogue back and forth. Because if you reply, if I'm one of the recipients, the only person that would receive my reply is going to be the manager. And then the manager can then take that and do the same process over again, if need be. That way, you avoid even the appearance of attempting to trigger the open meeting requirements of quorum and association discussion. And with regard to unanimous consent, hopefully that's a rarity. Michael is absolutely right. The legislature wants things done in the open. The reason that they take up this open meeting law every single year, it seems, and continue to put more and more requirements on it is because of the consensus and the feeling that boards aren't doing things in the open. And so the more that you can do things in the open for appropriate things, not privileged, not confidential, not things that the law says you do not do in the open, then the better. Yeah.
Perfect. Okay. I am going to very quickly touch on conflict of interest, and then we're going to do pop quiz and Q&A time here. Conflict of interest. Listen, just want to make sure everybody's fully aware. Arizona law is pretty clear about this, but basically, anytime you're making a decision that would financially benefit any member of your family or you, essentially. I mean, they go as far as to list out everybody listed here: parent, grandparent, spouse, child, sibling, any of their parents or spouses, basically your whole family. Anytime that's going to happen, that's a conflict of interest. You have to disclose that. You are not barred under the law from being part of the discussion or vote, although I will always tell you that it is my opinion, it is best practice that you also recuse yourself from the discussion and vote if there's potential that your family can be part of that financial gain, so to speak.
There's a question of whether or not a husband and wife can both simultaneously serve on the board. The answer to that question is it actually depends on your documents. Some associations say that only one person per household is eligible to run for the board. And then there are other communities that have no such requirement at all. And so I have seen where spouses, whatever the dynamic may be, have served concurrently on boards. And then I've seen other circumstances where two people want to be on the board, but their documents don't allow it. But the key that Michael's hitting home here is not every sensitive situation is a conflict of interest, or at least a statutory conflict of interest. It's when it's a decision or contract being entered into for compensation and it involves one of these people. That is when the legal statute is triggered and requires that there is a disclosure in an open meeting before engaging any of that dialogue or the vote in order for that to be an appropriate thing. And I would absolutely echo, we strongly encourage, even though the statute does not require this, we would highly recommend that anyone that finds themselves in this circumstance should consider to abstain from the dialogue or discussion and abstain from the voting. And you may even want to remove yourself. I've seen where it's been very helpful where people make the disclosure in the open meeting and then they look to the manager and say, "Manager, for this agenda item that I have a conflict on, I'm going to excuse myself outside of the meeting And after the deliberation and voting has been completed for this particular agenda item that I have a conflict with, if you could please just bring me back into the meeting so I can participate in the remainder of the meeting. I think that that's wonderful, because then you avoid, accusations that you inappropriately influenced or did something to force the other board members to vote in your direction.
All right. So just so everybody is aware, you all should be able to unmute yourselves now, which is good because we're going to do a pop quiz. We'll take the first answer either by chat or by unmuting yourself and speaking. The first correct answer. Charles and Maxwell and Morgan have generously offered to provide 4 $25 gift cards. So we have 4 questions to ask, and then we will take the correct answer for those, and those people will win the gift card. First question is, one of this year's legislative changes has to do with the foreclosure limits for planned communities. Can anybody out there tell us what we said the new limits were for time and amount?
$10,000 in 18 months.
Well, that's awesome. I'm pretty sure Joe or Alex beat you guys all in the chat. So Alex Black will win that one. All right, our next question, I will make note of that so I don't forget. Okay. Our next question is another change from this year's legislative session, deals with meeting recordings. If an association chooses to record a meeting, how long do they have to keep that?
6 months.
Is that Joe?
Yes.
Joe gets that one. Alex said Kathy beat him. So Kathy got you down for that one. And Joe, you get the second one. Okay, next one. We talked a little bit about flags, and I said an association has to allow or cannot prohibit the display of how many flags?
40.
2.
40 is correct. There are 40.
40.
I
Each
couldn't
40
unmute
flags.
my.
You cannot.
Darn it.
Who was the first person who chimed in there? Who was
I said 2. This is CJ.
I know you did, CJ. There was a gentleman who chimed in right away and said 40. Who was that?
That was Gordy.
40. Perfect. Gordy gets that one. All right. And our last one, maybe the toughest one, but we just talked about reasons you can go into executive session. I need somebody to give me 3 of the reasons you're allowed to go into executive session.
Legal advice, pending or contemplated litigation, or personal health or financial info, an individual, individual member of community.
Very good.
Brent.
Yep.
Fantastic.
Very good.
Those were the first 3. Appeals and hearings or job performance of specific individuals was the other 2, but you got the first 3 quickly. Perfect. So Kathy, Joe, Gordy, and Brent will be the winners of the gift cards. We will make sure you guys get those. And now it is.
My name is Kathy Joe.
That's hilarious, CJ. That's true.
Sorry, everybody.
Now it's Q&A time. Thank you guys for staying on with us a little bit longer. We have time for Q&A. So anybody have any questions for Charles in particular?
Charles, this is Lisa Collins, and just a question or a clarification regarding conflict of interest. If Charles could talk about that a little bit. I think that there may be some confusion with people regarding, it would seem like everything may be a conflict of interest because it benefits the person on the board that's voting. But if he could talk about that a little bit. My experience is in city government, and it's, if 10 people benefit, then it's not really a conflict. So if he could just talk about that a tiny bit, I'd appreciate it.
You bet. So I'll give you a real life example that I've seen within the last handful of years. I have a community, and the question came, I'm sure none of you have seen this or would ever deal with this, but they were dealing with whether or not they wanted to install a pickleball court somewhere in their community. And pickleball courts are all the rage right now. And so the question arose, there are those that are very much in favor of pickleball and those that are very much against pickleball. And when it was determined that they were going to install a pickleball court in this community, there were certain homeowners that came and said, well, wait a minute, that decision was not valid. And it wasn't valid because one of the board members lives in close proximity to where the installation of the pickleball court would be put, and they were a proponent. They wanted the pickleball, or at least they voted in favor of it. The question arose, is that a legal statutory conflict of interest? And the answer is no, it's not. There should be, and likely will be, a multitude of decisions that you make as board members that benefit you in some tangential way as a member in your community, whether that's choosing to have a fall festival and you attend and you get to see everyone happy and running around and having fun, or if it's to get a new landscape company that does a better job and the grass and the trees are more cleanly trimmed and pruned. You are receiving benefits from each of those decisions, but they're not compensation. Juxtapose that or compare that to the situation where I'm a board member, and I'll use that same pickleball example. Instead of just being a board member who is voting on the issue of whether or not the community wants to have a pickleball, what if I'm a contractor and my specialty is installing pickleball courts? And I'm one of 3 different vendors that are proposing bills or quotes to be selected. Is that different than the homeowner board member who just lives in the area of where a pickleball court is going to be installed? The answer is yes, because if I am selected and my company, whether I'm a low-level employee all the way up to the owner, if I'm going to be compensated in some way for that decision, then this conflict of interest statute is triggered, and I am required by Arizona law to make an announcement in the open meeting of my conflict of interest. Does that make sense? Is that a fair enough distinguishment between the two situations?
Yeah, absolutely. My experience is in local city government, which I dealt a lot with pickleball courts. So thank you. Thank you for that. That was a very relevant example for me. So thank you so much. I appreciate
We
that.
actually have a board member here who,
You're welcome. It is something I've seen a lot.
Yeah, thanks so much.
You're
we actually
welcome.
have a board member on here whose community installed a pickleball court in the last 18 months. So that's hilarious timing. But I was just going to say, yes, it's also important to note, not so much for you, Lisa, because I think you understand, but we do get questions at meetings sometimes about conflict of interest and open meeting law, where people want the same open meeting law and the same conflict of interest, or believe the same open meeting law and the same conflict of interest that pertain to public boards, public office boards, public office groups, to pertain to HOAs, and they don't. We have our own open meeting law and our own conflict of interest law, which are vastly different. But we do get that question from homeowners periodically. One of our newer communities, at our first meeting with them, somebody said, this isn't how the open meeting law works. And I had to explain to them at that exact point, you're referring to a public office open meeting. That law does not pertain here. Here's the law that pertains to HOAs open meetings.
And thank you, Michael, for bringing that up. It may be important for Charles to talk about that, because while it's different, there are still open meeting laws that are applicable to HOAs. So I don't know how different it is, but he may want to talk about that a little bit, since we're on the subject, since you brought it up.
Sure. So I've had different statements made at various times, and they've fallen in the categories of municipal ordinances, where someone says, well, I'm familiar with this, or I've had different accountants use different principles and say, well, I'm familiar with this. This is how you need to comport yourself and behave and follow these requirements. The answer is, in many situations, we have found that the thing that they are referencing is perfectly valid and applicable to their world that they are dealing with, but it does not always translate over into the community association world. We do have the Planned Community Act. We are absolutely subject to that if you live in a planned community. We have the Condo Act, which you're absolutely subject to the Condo Act if you live in a condo. The other is the vast majority of our entities that are established and recognized as legal entities in the state of Arizona are formed as nonprofit corporations under Arizona law, which also means that we are subject to the Nonprofit Corporation Act. But that does not mean that every other possible obscure statute, ordinance, or government rule and procedure is automatically imported into our world. In fact, what I have seen is many times the things that are actually being cited, if you take a close look at them, it often will reference and say, this applies to, and it'll tell you exactly who that particular provision or statute is designed to govern. And one example of that is, city councils. I've had someone reference statutes with regard to city councils to us as a board.
Yeah.
And I've had to let them know, thank you, this is not a city council meeting. This is a board meeting, which is a entity of members formed under the Nonprofit Corporation Act. So it does sometimes need a little bit of clarity, but by and large, the vast majority of the time, we're looking within those three sets of statutes: the Planned Community Act, the Nonprofit Corporation Act, and the Condo Act, if it happens to be in a condo.
Right. Thank you. And thank you for referencing Section 33 of ARS. Thanks.
You're welcome. Thanks for being here.
Anybody else have any questions
I
for
have
Charles?
a quick question.
Yes,
So-
sir.
Ann was telling me that, and I must have missed this update, that when we do a motion in a second, that the homeowners have an opportunity to, call it, comment.
Yep, that's absolutely true.
No, I'm not.
So,
I'm not questioning that part. What I'm questioning is,
Oh.
let's just say they object or whatever. Can they basically filibuster until we give up, or how does that work?
No,
Yeah,
that's a great question, and I'm going to tell you that your conduct of meetings policy, I think, says 3 minutes. You can restrict them maybe even as low as 2 minutes, but I think we put 3 minutes in the conduct of meetings policy. They can talk for 2 minutes, and if you have a bunch of people wanting to talk on a subject, you can limit the number of speakers for or against that topic, and you only have to give them the 3 minutes each. You cannot borrow or use somebody else's 3 minutes. You do not have to give them any sort of reply or answer. If they ask a simple question that you can answer, great, give them an answer. Otherwise, you can thank them for their comments and move on with the meeting.
Okay, do we have to
Yeah.
poll them, or if they just generally nobody says anything, can we just move on?
I think it's best practice after the motion and second to say, do we have any questions or comments from the homeowners? I think if you
No, I
fail
mean,
to do that, you run into the
if they fail
possibility.
to say anything, we don't have to ask each one individually, is what I'm saying, Michael.
No,
No.
absolutely.
Thank you.
good question. And what I've encouraged boards when I do training with them is, remember, this is not an interrogation. It's not a deposition. This isn't I pose a question and you're mandated by order of the court to respond. You also want to be cognizant of your situation. You don't want to have a negative or adversarial environment all the time. But what I've encouraged people to do is set forth at the beginning of your meetings the parameters of what the expectations are. And if you've got these policies that Michael's referenced, that's great. And so you can just say, as a reminder, we welcome comment at an appropriate time by members. We would, afford 3 minutes per person, and it needs to be on point for that particular agenda item. I've had people that get up, kind of, as you've mentioned, and try to filibuster, and they start going off on tangents that have nothing to do with the agenda item. That's when it's appropriate for a manager, board member, if I'm there, an attorney, to simply redirect and say, hey, thank you, but that thing that you're talking about right now is not part of agenda number 3. Do you have any comments on this agenda item? And if they do, great, then they get to use the rest of their 3 minutes. If they don't, then it's okay, thank you, we're going to now proceed with the remainder of our agenda. It's about being professional and courteous as much as you possibly can, but also helping, because sometimes people just simply don't know what they don't know. And there is a little bit of an art to running meetings, whether it's in government, whether it's at an HOA board. So helping people understand what the parameters and expectations are can be very helpful.
We have a condo board who a couple of the board members were on. They're not with us anymore. Who I sat in on a meeting before where we printed out their conduct and meeting policy because they wanted to have quarterly in-person meetings, virtual the months in between, but the quarterly in-person meetings, people were, at the very first one, people were a little liberal in their speaking, and both the board and manager had a hard time kind of controlling that. So I went to the second one, and we made sure we had copies of and handed out the conduct and meetings policy. But we even had one person who left when we said, that's not what we're discussing right now. Do you have anything on this topic? And he was like, is this not a meeting for homeowners to chat? And we're like, well, homeowners can chat at the open forum and on whatever topics the board's voting on. And the person got up and left. They didn't like that. But it needed to be done there. We don't like to always take a kind of a firm approach. We like to be pretty open. Not that many people attend meetings, kind of let them participate to a reasonable extent, but sometimes you've got to bring the document, share the document, and remind everybody.
Well, at the end of the day, a good reminder is that a board meeting is the board's meeting to do the business that is before them. It's not an annual meeting. An annual meeting is a meeting of the members. They can get together, they do their vote, and they can, have a nice gathering and do what they choose, to a certain extent. But a board meeting, you're there for a specific purpose. You have an agenda, and the reason you've been elected by your membership, presumably, is so that you can properly officiate over the needs of the community in an appropriate and timely way. And that timely way is at those meetings. And if you have someone who kind of derails that by commandeering all of the time and, going off on tangents, then the likelihood that you're going to be able to be effective is diminished. And that's unfortunate for everyone. So.
Real quick before we say goodbye, which realized I saw you wave earlier. Charles, I thought you were like waving out the door at somebody, but this time around I realized that your lights go off and you have to turn the lights back on with motion. I like that.
Yes, I'm not trying to dance over here. I should just change my timer to where it's much more prolonged, but everyone else is out of the building. And so if I don't move from away from my monitors every few minutes, my office is going to go dark.
I like it. Well, first of all, thank you so much for your time this evening and all of the information you provided for the PowerPoint and helping us get through this, and for the gift cards that we will pass along to the appropriate board members. And
Awesome.
For the couple of board members that are still on, thank you all very much for your time this evening. We really appreciate your time and attendance.
Thank you, everyone.
Thank you for
Appreciate you
having
very
us.
much.
Appreciate the information.
Have a good evening, everyone.